Good afternoon, sir. Can you see and hear me?
Yes, thank you.
Thank you very much. In a moment, I'm going to turn back to just one additional set of questions on prosecutorial policies and who was responsible for decision making. But there's a slight IT problem which needs to be resolved before I do so. So can we turn to a separate topic, please, which is expert evidence? Can we turn up page 23 of your witness statement, please? And it's paragraph 51. You tell us the guidance given to expert witnesses called on behalf of the Post Office was the same as that of a non-expert witness, namely that the witness statement should be truthful, and if it were otherwise, they could be liable to prosecution. Yes?
Yes.
And then in the remainder of the paragraph, is this right? You go on to tell us about some duties that an expert in fact owes.
Yes.
So dealing with the first sentence then, what guidance was given to expert witnesses?
I don't recall.
Well, hold on, I haven't asked the question yet.
Oh, sorry.
I was pausing myself.
Okay.
In relation to what you say there,
Yeah.
the guidance given was the same as a non-expert witness, namely they should be told to tell the truth, and if it proved otherwise, they could be liable to prosecution. That tends to suggest that they were told two things, yes? And they were only told those things that also applied to a witness of fact, a non-expert. Is that right?
Sorry, say that again, please.
Yes, it tends to suggest that they were told the same things as applies to a witness of fact, a non-expert witness, namely the duty to tell the truth and the consequences if they didn't tell the truth, i.e. they could be prosecuted.
Yes.
You may know that we've received some expert evidence ourselves on the duty of an expert witness across the period 2000 to 2013 on the relevant duties of an expert witness and upon the duties upon a prosecutor seeking to rely on an expert witness across that period. And I want to put, if I may, some elements of the evidence that we heard to see whether you agree or disagree with them. Would you agree that the prosecutor must provide an expert with instructions as to the issue or issues upon which his or her opinion is sought?
Yes.
Would you agree that the prosecutor must provide the expert with questions which the expert is expected to address or to answer?
Yes.
Would you agree that the prosecutor must supply an expert with material upon which the prosecution relies and which may be relevant to the questions which the expert is expected to answer?
Yes, if the evidence is relevant, yes.
Do you agree, secondly, that throughout this period, 2000 to 2013, a prosecutor intending to rely on expert evidence in criminal proceedings was under a duty to satisfy themselves as to the expert's relevant qualifications and expertise?
Yes.
They were required to satisfy themselves that the expert had been appropriately instructed, included by the provision of a letter of instruction or terms of reference.
Yes.
That they were required to satisfy themselves that the expert had been informed as to their relevant duties, including a duty to the court.
Yes.
The prosecutor in that period was required, would you agree, to satisfy themselves that the expert had understood and had complied with their duties to the court?
Yes.
The prosecutor, would you agree, was required to satisfy themselves that any literature or material which undermines the expert's conclusions had been reviewed by the prosecutor and, where appropriate, disclosed to the defence?
Yes.
And lastly, the prosecutor was required to bring to the attention of the defence and to the court any material which the prosecutor was aware was reasonably capable of undermining the expert's opinion.
Yes.
And that includes matters relating to the expert's qualifications, the factual basis for their opinions, and their credibility.
Yes.
Thirdly, would you agree that if a prosecutor wishes to rely on an expert witness in this period, the prosecutor must be or is duty bound to ensure that the individual concerned, the expert, actually understands that they're giving evidence in the capacity of expert witness, and therefore special duties apply to them?
Yes.
Fourthly, would you agree that any duties of disclosure that are required to be discharged are those of the prosecutor, and that they can't subcontract them to the expert themselves?
Yes.
Fifthly, would you agree that if a party seeks to rely on an expert who is not functionally independent of a party in the case, then the party is under an obligation, a particular obligation, to show that the expert understands the duties to which he or she is subject?
Yes.
And that applied in this case, in that if expert witnesses such as Mr. Gareth Jenkins were called, who were not functionally independent from the post office, they were not akin to conventional experts who were accustomed and trained to giving expert evidence. You were under, and your team were under, a particular duty to ensure that those individuals, including Mr. Jenkins, understood the duties to which they were subject.
Yes.
You tell us at the beginning of this paragraph that the guidance given to expert witnesses, what they were told they needed to tell the truth, and if they weren't, they could be prosecuted. Does it follow that the list of things that I've just read out were not undertaken in relation to experts called by or on behalf of the post office in the relevant period?
Yes.
And how did that come about then?
Because at the time, I believed that Gareth Jenkins understood his duties, that he was cross-examined by the defence and examined in chief by the prosecution to outline his expertise, and that from that information I believed that he fully understood that he was independent and objective, irrespective of the fact that he was employed by Fujitsu and was giving evidence in relation to his employer and Post Office Limited.
The things you've just spoken about there all happened once he was in the witness box.
I understand that.
The things I've spoken about happen before we get to the witness box, don't they?
Yes.
What was done to ensure the list of things that I have read out, that all happen before somebody walks into the witness box, were done?
I don't recall. I don't specifically recall ever seeing Mr. Jenkins, although I must have met him at some point in time. And I believe I may well have been present when he was in court, although I can't recall that happening.
If we go forward to paragraph 54 of your witness statement, please. Thank you. And it's the last line. You say something similar to that which you said a moment ago. Quote, Gareth Jenkins was aware that his duty was to the court and not to the criminal law team who instructed him or Fujitsu who paid him.
Yes.
On what basis do you say that Gareth Jenkins was aware that his duty was to the court?
Well, I believe that he will have understood that from either the solicitor dealing with him in the particular cases that he was involved, or indeed from when he was cross-examined by the defence or examined in chief by the prosecuting barrister when he was giving evidence. I believe it will have been explained to him then, and that he would have known on the first occasion.
Thank you. That can come down. Was there any post office policy guidance or protocol which reflected any of the principles which I've grouped into 5 and which I mentioned a moment ago?
No.
Was there therefore a complete absence of any post office policy guidance or protocol giving instruction either to investigators or to prosecutors as to how to handle expert evidence?
Yes.
Can you identify any steps that were taken to satisfy the criminal law team that Mr. Jenkins enjoyed relevant qualifications and expertise?
Sorry, can you...
Yes. Are you aware of any steps that the criminal law team took to satisfy itself or themselves, the members of the criminal law team, that Mr. Jenkins enjoyed the relevant qualifications and expertise to give evidence as an expert?
I believe that his credentials were looked up. I may be wrong in saying that I thought he was a professor. He certainly had some qualifications that appeared to be relevant to his position within Fujitsu. I forget whether it was a doctorate or some other qualification. So my understanding from his qualifications is that he appeared to be an expert in his particular field.
Are you aware of any steps taken by members of the criminal law team to ensure that Mr. Jenkins was appropriately instructed by provision of a relevant and detailed letter of instruction or terms of reference?
I don't know when he was identified as an expert witness. That could have been before I took over the team. But if it was when I was in the team, then that issue was not addressed.
Are you aware of any steps taken by members of the criminal law team or by yourself to satisfy themselves or yourself that Mr. Jenkins had understood and thereafter complied with his duties as an expert witness?
I don't recall.
What steps, if any, were taken to ensure that the documents that Mr. Jenkins produced and which were submitted to the court by way of a witness statement rather than an expert report complied with the requirements at common law before 2006 and then by reference to the criminal procedure rules from 2006 onwards as to the contents of an expert report?
I don't know what steps were taken, but I believe that from his witness statements that had we failed to deal with that properly, then counsel would have pointed that out to me.
Are you aware of what were called the Icarian reefer duties in terms of the contents of an expert report?
I don't recall that, no.
Do you remember those requirements which arose in a civil case called the Icarian reefer being applied at common law to criminal proceedings?
I don't recall.
Do you remember in 2006 the criminal procedure rules incorporating them as a matter of law from the common law into the criminal procedure rules? There are 13 requirements of also of an expert report.
I may have done at the time. I may have at the time, but I can't recall now, I'm afraid.
You mentioned a moment ago that you would assume or believe that if the report was in any way deficient, that counsel would have pointed it out to you.
Well, not necessarily prosecuting, but defence counsel as well, yes.
That's not really how the law operates, though, is it? I think
No,
you'll understand.
I fully understand that, yes.
That duties imposed by the law, by statute, or in delegated legislation, or another form of legal instrument, are imposed on the prosecution, and one can't delegate that to the defence to pull you up.
No, I do understand that, yes. It was my responsibility.
In your witness statement at paragraph 19, I wonder whether we could turn that up, please. It's on page 10. This was in answer to a question that I think we directly asked you as to what independent oversight was exercised in respect of the conduct of prosecutions. You answered at 19, there was no independent oversight exercised in respect of the conduct of prosecutions. Is that right?
Yes.
Does it follow that you wouldn't regard the instruction of counsel to prosecute a case as a form of independent oversight?
I didn't consider counsel in the context of the question. I thought you meant some external body like the Attorney General's office or the Crown Prosecution Service.
Thank you, that can come down. Do you, with me reformulating the focus of the question, think that counsel instructed by the Post Office provided some form of independent oversight in respect of the conduct of prosecutions?
Yes.
Who ordinarily settled the indictment in a case that was committed to the Crown Court?
Counsel. However, the solicitor drafted the indictment for counsel's consideration and approval.
Was there a policy that counsel had to advise on evidential sufficiency in each case?
Yes.
Did they therefore have to advise in every case that there was sufficient evidence of a realistic prospect of a conviction?
Yes.
Can we just turn up paragraph 33 of your witness statement, please? Which is on page 15. And if we scroll down, thank you. You say there were occasions when counsel's advice was sought prior to a decision to prosecute being reached. The CLT did not seek advice from external lawyers. Seeking advice from counsel on certain matters continued throughout my role in the CLT. Such advice was occasionally sought in complex matters. That's rather different from what you've just said, which was that in all cases, counsel advised on evidential sufficiency.
Yeah, no, what I'm saying there is that in complex cases, we would ask counsel for their initial advice prior to drafting charges. But this paragraph 33, so that's paragraph 33. But what I was saying before was once we had charged and the case had been committed to the Crown Court, we would seek counsel's advice on every case. Counsel's
advice about what?
The evidence.
What about the evidence?
Whether it's sufficient, whether we needed to expand the investigation, lines of inquiry, anything to do with the up-and-coming Crown Court case.
So have I got this right? There was no policy that counsel had to advise pre-decision to charge or decision to initiate a prosecution?
Yeah, only...
That happened occasionally?
That happened occasionally in complex cases. If we weren't sure of the direction where it was going, what we needed, if we needed any assistance,
yes,
that initial case would go to counsel. Usually only complex cases.
Right, that's paragraph 33.
Yeah.
That can come down. And then on the other hand, you're telling us that in every case, counsel advised, as a matter of course, post-initiation of proceedings, on whether there was sufficient evidence to secure a realistic prospect of a conviction.
Yes.
So in all of the cases we're going to look at, we should find such an advice.
Well, it's not whether there was a realistic prospect of conviction. It's whether we needed to get other evidence, whether there were lines of inquiry that counsel would suggest that we ought to pursue.
Right, well, that's rather different from what you said a moment ago.
I'm sorry that I've misled you.
We've certainly got advices where an advice on evidence, where counsel says, on page 444, there's a reference to Mr. So-and-so. He ought to be traced.
Yeah.
On this exhibit, it's got the exhibit reference SG1. I think that should be SG4. Or is there an SG4? Or something like that.
Yeah.
Or we need to bottom this out or that out.
Yes.
Not in each and every case addressing fundamentally or addressing at all the question, on the evidence before me, there isn't or there is not a realistic prospect of conviction.
Yeah, no, I'm sorry, I misunderstood your question.
Why wasn't such advice sought?
About the realistic prospect of conviction?
Correct.
Because I believe that when the case had been committed for trial, there was sufficient evidence to afford a realistic prospect of conviction.
What duties did you understand counsel to be subject to after a prosecution had been initiated in reviewing the state of the evidence?
Well, I think counsel's duties would be to point out to us if there were any failings in the evidence, whether the case was robust enough to continue within the Crown Court, but advise on additional evidence if appropriate.
And so even if they weren't asked to advise on whether there was a realistic prospect of a conviction, did you understand them to hold a professional duty to review the evidence and to advise if they considered that the evidential test, or indeed the public interest test, had not been met?
Yes, I'm sure council would have done that automatically.
Can you recall cases in which that happened?
No.
Can we turn to a new topic, please? Good. I'm told that we can now turn to the hangover from this morning. Can we go to poll 303 1010? Ms Price, over the lunch hour, helpfully pointed out that there was an additional document in the run of policy documents that addressed the issue of who took the decision to prosecute sub-postmasters and counter-clerks that I ought to draw to your attention. Can we just look at the foot of the first page, please? A bit more, thank you. Can you see this is dated June 2002?
Yes.
And if you look at the top of the page, it's described as an investigation and prosecution policy. Its purpose is to set out the criteria against which Consignia investigates crimes and suspect crimes committed against the businesses, and also defines when actions proceed under the criminal law. Would this policy apply to the prosecution of sub-postmasters and counter-clerks?
Without seeing it all, I'm not sure.
Well, thankfully, it's only a page long. So if we can just scroll down slowly and let you read it, because I don't think you'll have seen this before.
Certainly 3.2 reporting offences, they're all Royal Mail offences.
The reason for asking you is that there's a sign-off box on the second page.
Yes.
And if we just go to the second page, you can see that amongst those who gave assurance to the policy, you are named.
Yes. It looks to me as though that's a Royal Mail as opposed to a Post Office Limited document because of the people who are involved. Garth McCarran and Paul Woods and Paul Booth, as far as I'm aware, were never in Post Office Limited. They were Royal Mail investigators.
And so this policy wouldn't apply to the class of suspects and defendants that we're here considering?
No, it wouldn't have.
Can I just, out of completeness, however, draw your attention to what 3.3 says on the first page? If we scroll down, thank you. Each case will be dealt with on merit, and action taken, if any, will be in accordance with the disciplinary code of the business. Where evidence of crimes committed by a Consignia employee against Consignia or its customer is established, the offending employee may also be dealt with in accordance with criminal law. The prosecution guidelines of the business will be used in making any decision to proceed under criminal law in consultation with SIS, that's the Security and Investigation Services, and the Legal Services Criminal Law Division where appropriate.
Yes.
Does that also indicate that this isn't a relevant policy?
Yeah, I think what it's saying is it could be Parcel Force, it could be Royal Mail, but as I say, those three individuals that I named were not Post Office Limited investigators.
In which case I'm not going to ask you questions about where that statement of policy may fall short. Can we move on then, please, to the issue of pleas, guilty pleas?
Yes.
The inquiry is in possession of a large body of material which appears to suggest that pleas would not be accepted, guilty pleas would not be accepted, in cases where the basis of plea called into question the integrity of Horizon.
Yes.
Does that sound, as a high-level statement, something with which you were familiar in the relevant period we're looking at?
Yes.
Can I just look at 3 examples of that in action? Can I again start with the Court of Appeal's decision in Hamilton? And I'm using it because it collects together quite a bit of material conveniently. Poll 0011 3278. And it's page 41, please. And can we look, please, at paragraph 167? Which starts at the foot of the page. The court says these factors, that's the factors addressed in the preceding 3 paragraphs, are sufficient for the court to quash Mrs. Hall's convictions on both grounds 1 and 2. We were, however, presented with further information which bolsters our conclusion that Mrs. Hall's prosecution should not have been brought and which forms the basis of the Post Office's concession under ground 2. On the 30th of June 2011, the Post Office's external solicitor wrote to you recording what had taken place in court that day, including the basis on which Mrs. Hall had pleaded guilty to fraud as an alternative to theft, despite the fact that Mrs. Hall had not sought to make any express criticism of Horizon in her defence. The attendance note records the fact that it was made clear that, quote, the prosecution would not accept any criticism or blame concerning the Horizon system. The Post Office accepts that it was improper to make the acceptability of Mrs. Hall's basis of plea to fraud conditional on not making any criticism of the Horizon system. Can we look at the second source of evidence? I could look at them all 3 and then ask you some questions, please. Poll 305 5783. This is an exchange of emails with Diane Chan, who I think is was counsel who prosecuted cases for the Post Office. Is that right?
Yeah, that's right.
And it's an exchange with you, and I think we can glean what's necessary from the top of this page. You say to her on the 17th of November 2010, Diane have received a defence statement today despite the telephone conversation earlier, hard copy put in the post. At point 2, the defence alleged that any discrepancy was as a result of the Horizon system. There's also a challenge to the initial missing figure of £18,000, which was reduced according to the defence statement in a matter of minutes. The statement also maintains that further investigation by the auditor, quote, would have discovered the whereabouts of the alleged missing sum. And then you say, clearly, if there were to be a plea to false accounting, but on the basis that the Horizon system was at fault, that would not be an acceptable basis of plea for the prosecution. And the last piece of evidence, please, poll 306 9878. And if we look at page 2, please. This is from a member of your team, Ms. McFarlane, yes?
Yes.
If we just scroll up, please, to the page above so we can just get a date. 1st of December 2006. Yes? And then scroll down, please. Mandy, Thomas is my case. He was charged with theft of about £48,000. He blamed the online banking system, claiming that reports had several transactions showing nil transaction. This was looked into, and the investigator remained of the opinion that the entries were deliberate and to facilitate fraud. Mr. Thomas's expert examined the horizon, I understand, from the officer that he took no issue with the system and informed the officer that we would be hearing no more. No defence expert report was served. Following the visit, Mr. Thomas's solicitor offered a plea to false accounting that in doing so he would not blame Horizon. This was accepted to avoid the cost of a trial, 9 months imprisonment, confiscation proceedings. So this is describing a plea negotiation involving Hughie Thomas, yes?
Yes.
On the basis that the plea would not involve a blame being directed towards Horizon. Now, you address this practice, plea negotiations on the basis of Horizon never being blamed, in your witness statement at page 25. I wonder whether we could turn that up, please. And it's paragraphs 57 to 59. You say there are examples in a number of prosecutions where plea bargains were struck before trial, where the post office would offer no evidence on a charge of theft in exchange for a guilty plea on a charge of false accounting. You give some references. I did not draft charges, you say in 58, of theft in order to put pressure on defendants to offer guilty pleas to charges of false accounting. Charges of theft were only drafted when the evidence was such that it was believed there was a realistic prospect of conviction of the offender in relation to the theft charge. 59, I considered that a plea to false accounting would not be acceptable if it was put on the basis that the Horizon IT system was at fault, because I did not believe this was true, and as such felt that such a plea could not properly be accepted. In your years of operating as a lawyer in the criminal law team and then as head of it, had you ever heard of a decision of the Court of Appeal called Eden addressing the post office charging practice of charging counts of theft and false accounting?
Yes.
What guidance was issued to prosecutors about the Court of Appeal's comments about the Post Office's practice of charging those counts on an indictment?
The guidance that I gave was that they should not charge alternative allegations of theft and false accounting, that they should follow Eden.
And where is that written down?
I wrote it to my team.
In a guidance document?
No. I noticed that there was a practice amongst some lawyers of charging both theft and with an alternative false accounting, which I disapproved of.
And why did you disapprove of it?
Well, because it didn't follow RV Eden.
And in what respect was it wrong?
Well, it was wrong because RV Eden effectively said you should pin your colours to the mast. There is a case of RV Julian Wilson amongst the papers.
Yes.
Where I took on some papers that one of my colleagues was responsible for. They were on holiday. My practice in charge of being in the criminal law team was that if somebody was on holiday, it was an opportunity for me to undertake work that was necessary at the time to see what was going on cases. It was one of the measures that I took. In this particular case, Julian Wilson, the lawyer had charged both theft and false accounting. I prepared the instructions for counsel because the case had been committed for trial, and I dropped the charge of theft, proceeded with the charge of false accounting, and in the instructions I referred counsel to my opinion that there was the evidence in relation to theft was not, I can't remember how I described it, but was not good, and that's why I had dropped the theft charge and preferred the false accounting. Now, I will have taken that up with the lawyer involved, and at that stage I would have probably reminded the team that my instructions were that you shouldn't charge both theft and false accounting. You should be pinning your colours to the mast.
Thank you. Was there anything akin to a playbook or a rule book for the criminal law team?
A playbook?
Yes, a set of standing instructions as to how they were to go about their work.
No, but as the head of the team, I received the post every morning, so I could monitor what was going on in relation to individual files, and if I had any concerns about what was going on, I could sometimes see it with the post. Like I've just told you about the case that I took over for somebody who I believe was on holiday at the time. That was another way I tried to monitor cases. And if I had any, and I also did a random check on committal cases that were in the legal execs room where the cases had been committed for trial. I did a random check on a, I don't know, 6 monthly basis, 3 monthly basis, I'm not sure what it was.
Like a dip sample?
Yeah. So I did that sample. And as a result of those checks, if I felt there was something amiss, then it would be flagged up to the team. And one of my concerns did involve a number of lawyers charging both theft and false accounting.
Did that happen more than once?
Yeah, more than once.
Why was it happening more than once?
Because people weren't probably listening to me.
You tell us in paragraph 59 that a plea to false accounting wouldn't be acceptable if it was put on the basis that the system was at fault because you didn't believe it to be true.
Yes.
Was that a belief which you shared with the rest of the criminal law team?
I will have done, yes.
Was therefore this belief something that was turned into a policy applied in a similar fashion by other prosecuting solicitors under your supervision?
Not necessarily.
Do you think some of them accepted pleas to false accounting on the basis that the Horizon IT system may be at fault then?
No, the Code for Crown Prosecutors in 2010, at paragraph 10.4, if I've quoted it right, headed acceptance of guilty pleas, is fairly specific in that it says that if the prosecution and the defence disagree in terms of the basis of plea, then the matter may be referred for the prosecution to actually call evidence. So my understanding was that it was perfectly proper to require, to put our case effectively to the defence. This is our view. And following from that, if I'd not said that we were challenging what the defence's view was, then it would be tantamount to me saying, we accept there's a problem with Horizon.
Where did I'm sorry.
So I was really following what was in the 2010 Code for Crown Prosecutors at that section.
And what you're referring to there, I think, existed in practice before then, that if there was a material dispute as to the basis on which a person might be sentenced,
Yes.
in some cases it would be permissible to essentially canvass that with a court, but in others it would be necessary for the dispute to form up to a Newton hearing.
Yes.
So I don't think there was anything new in the code then.
No, there wasn't, but I did double check it because my understanding was that you would have a Newton hearing, as you've just said.
But by the same token, what was the basis for your belief that there were no faults with the IT system, the Horizon IT system, that were capable of forming a basis of plea or indeed relevant mitigation?
Well, because at that stage we will have had a committal bundle, which will have had evidence from Fujitsu, possibly from Gareth Jenkins himself, effectively saying that the system is sound.
And so it was the Fujitsu evidence that allowed you to have the belief that there were no material faults with the Horizon IT system?
Absolutely, yes.
By this time, if one picks the period of 2010, had there been any independent assessment of Horizon's integrity?
There hadn't been an independent assessment, but Rod Ismay had prepared his report, I think it was in August 2010, which effectively vindicated the Horizon system.
And is that how you read the Ismay report, that it was a vindication of the Horizon system?
Yes.
Did you regard it as thoroughly independent and objective?
Yes, I believe it did. As far as I was concerned, it vindicated the system, yes.
We're going to come back to Mr. Ismay's report later, but he's told the inquiry that his instructions were, his terms of reference, were to look for and to include only evidence that showed that Horizon was a robust system and that the data that it produced enjoyed reliability and integrity, and not to include anything that showed otherwise. Did you know that?
No.
That it was a deliberately one-sided effort?
No, I didn't know that at all.
That the dice were loaded before he even set pen to paper because it was a myopic view that only looked at material to back the system?
No.
You didn't know that?
No. No, I didn't at all. I think...
He's told us these things from the seat that you're sitting in.
Yes. No, had I known that, then I wouldn't have given any credence to the well, I think I'd have asked him, well, what was wrong with the system at the time then?
Well, I think he would have replied, I'm not allowed to look. Were you relying on Mr. Ismay's report after August 2010, therefore, in adopting this practice of refusing to enter plea negotiations if they involved any blaming of the Horizon system?
Well, I wasn't refusing to enter plea negotiations. What I was saying to the defence is, depending on what they said in the defence statement, look, our view is contrary to your view, and that therefore this issue may have to be resolved by calling evidence.
Thank you. That can come down. Were you aware of, by autumn 2010, of the discovery of the receipts and payments mismatch bug?
Was that the Juliet McFarland bug?
No, I don't think it was, from memory.
Is this the 40 officers?
I'm sorry.
There were 40...
14.
Officers.
1-4.
14?
Yes, I think.
No, I was aware of the Juliet McFarland where I think there were two, the Horizon, it was the New Horizon problem. I was aware of a Dave Posnett single office problem, and I was aware of John Longman's. I don't recall the 14, and don't believe that there are any documents in my papers that refer to that one.
Did the information that you received about the problems that you have just identified to us affect your faith in the integrity of Horizon?
Horizon, the 2007 problem that Dave Posnett referred to, as I recall, was a single office. A fix had been implemented the year after, and we were told in 2009, and I wrongly took the view that needn't be disclosed. I felt at the time, now looking at it, I should have disclosed that issue. I don't think I considered that the integrity of Horizon had been destroyed by that. The Juliet McFarland issue, we disclosed to the defence, and I believe it was referred to in a generic witness statement that was prepared by Fujitsu. And the John Longman case, I've recently received some papers from you which explained what the case was concerning 40 officers where there was a problem, and I've been able to read that, and I don't know what happened with that case, but that, as far as I can understand, it was a New Horizon issue. So far as Old Horizon was concerned, I didn't have any belief that there was a problem, A, because of the Rod Ismay report, and B, because the Seema Misra case had been comprehensively challenged, and we'd secured a conviction, and I thought that supported what we were doing.
Thank you. We're going to come back to those 3 disclosures of bugs.
Yes.
When you return on the 12th of December.
Right.
And some others too.
Right.
Whether you, or the extent to which you knew about other bugs when making disclosure decisions.
Right.
Can I turn, as you've mentioned it, therefore, to the Ismay report? Can we look, please, at poll 2010-6867? And if we look, please, at page 3. And scroll down, please. We can see a message from Mr. Hayward of the 26th of February 2010 at 5:01 to a range of people, rather senior people within the post office, but not including you.
Yes.
You can see that it refers to a conference call earlier in the day. I think that's a conference call in which you did not participate, is that right?
That's right, yes.
And it sets out some agreed next steps. Can you see those listed at 1, 2 and 3?
Yes.
The first one, Mr. Hayward and Miss Talbot to provide Sue Lowther and David King with information on past and present cases with reference to the Horizon challenges, both criminal and civil cases. And Mr. Hayward notes, I've asked the fraud team to review about approximately 2 to 3 years past case files, although these challenges are of a more recent nature. And then at paragraph 3, subject to 2 above, conduct full investigations into integrity issues with the conclusions report provided. Once investigated and conclusions drawn, gain external verification to give a level of external gravitas, in inverted commas, to the response to these challenges. Recommend Ernst & Young as most suitable partner to complete this, to be advised. Would you agree that this evidence is a plan amongst relatively senior members of the Post Office the Post Office team, setting out a plan to investigate Horizon integrity concerns and challenges?
Yes.
And first, there was going to be an investigation within the Post Office, an internal investigation, and then an independent review by external consultants, possibly Ernst & Young.
Yes.
Would you agree that this apparently suggests that there was sufficient concern to consider an investigation to be necessary?
Yes, I imagine it was.
Would you agree, because it would be important for the Post Office as a business, but also as a prosecutor, actually to appreciate whether or not there were integrity issues with Horizon?
Yes.
And that would be important to know to determine whether future investigations and prosecutions could be conducted, but also whether duties of disclosure might arise in respect of convictions cases where convictions had already been obtained.
Yes.
Did that independent review, to your knowledge, ever happen?
Not in the time that I was in the Post Office, no.
Can we go forwards, please, to poll 305 4371? And go to page 2 at the bottom, please. And keep going a bit more, please. We can see an email an hour later from Mr. Hayward to the same group of similar people, again, not including you.
Yes.
Albeit a month later, I think you get this chain, because we just saw from the top you get it in March. Mr. Hayward, says, further out to our discussion today, additional information in the attached PDF article below as part of the wider review. It may well be worthwhile understanding the outcome of each of the case studies referenced where applicable, and that may assist in our review. And so this was Mr. Hayward apparently circulating an article that covered issues about Horizon integrity and contained some references to cases that might need to be included in the review.
Yes.
Can we go to poll 2010 6867? And go to the bottom of the page, please. Keep going a little bit more, thank you. Picking up the chain where we left it off, you're now added to this chain as a copyee. Can you see that?
Yes.
And Mr. Posnett says, can we please ensure that Rob Wilson, Head of Criminal Law, is kept appraised of the, and then we have to skip a page, situation and included in any further meetings on this subject. Our prosecution cases have faced an increase in challenges as well as our civil cases. So the activities below and indeed going forward are applicable to both legal teams. Would you understand the reference to both legal teams being the civil and the criminal law
Yes.
teams? Thank you. So you're now being included.
Yes.
Can we go to the top of the page, please? Top of page 1. We now have your response
Yes.
on the 3rd of March, so 5 or so days later. Can we deal with that after the break, please, sir? And take a 15-minute break until 3:15.
Sorry, I was on mute. I said certainly.
Thank you very much, sir. Good afternoon, sir. Can you see and hear me?
Yes, I can.
Thank you. Mr. Dawson, we were looking at poll 00106867. And just to remind ourselves of where we are on the foot of the page, Mr. Posnett had copied you in on the 1st of March to the exchange that had happened on the 26th of February, and you replied on the 3rd of March 2010. If we look at the top of the page. Do you know why you weren't involved in this conversation from the outset?
No, I have no idea.
You were a bit annoyed about that, weren't you?
Certainly was.
We can see that from the last paragraph of your email, where you say, given the nature of the discussions that took place on the 26th of February, I'm staggered I was not invited to take part in the conference. Why were you staggered?
Well, because my team needed to know what was going on, and if there was such a concern within the business, then I needed to know that.
And why did you need to know it?
Well, because I was responsible for the prosecutions. If I, if I wasn't aware of what was going on around me, what was I going to do as a prosecutor? I needed to know that if there was a problem in the system, what the problem was, and I was completely staggered.
Your response, however, isn't to say I needed to be included because I need to know in order for me and my team to discharge our responsibilities.
No.
Your response is to give a list of reasons to not do what was proposed.
No. I mean, the first sentence in that response is effectively saying that if it is thought there's a difficulty with Horizon, then clearly the action set out in your memo is not only needed but imperative. I mean, that's the response.
But then the rest of it is a but, isn't it? The entirety of the page is then a but. Clearly, if you think if there's a problem, we need to do something. However, and then you give a list of half a dozen reasons not to do that, don't you?
Well, within 5 days of this, I'm being told by Dave King that they're going to do a report, and I'm not saying don't do the report. I think this was just a reaction to having been excluded for what I considered to be very important. And basically, it was me throwing everything onto the page that I probably would have said in a different way had I been in the meeting.
So you saying that you can explain away the fact that this lists, by my reckoning, 7 reasons not to commence an independent investigation, the reason for that is pique or anger at not being invited to the meeting.
Yeah, I'm not trying to explain it away. I'm just trying to sort of, my mindset at that particular time was I need to know if there is a difficulty with Horizon, and yet there was a meeting that went ahead. I don't know how long it took, what detail they went into. I need to know this.
But you don't say that.
I know I don't say that, but what I'm saying to you is that my mindset at the time was I was angry, and I've acknowledged that, yeah, if there's a problem, there's a problem, and we need to deal with that. But here's some stuff that I might have been saying at the meeting, as I say, not necessarily in that particular way, but I would have obviously been able to listen to what was going on in the meeting, what the concerns were, and tailored my answer to that meeting, as opposed to having a blank page because I didn't know what had been going on and throwing everything down.
Are you tailoring what you say now to try and explain away the contents of this email, trying to explain it away on the basis of anger or frustration?
No, because like I said before, within 5 days, I'm contacted by Dave King saying, we're going to do this exercise. And I don't say, well, you can't, or don't do it, or whatever. I just say, okay.
But that never happened either, did it? What happened was the ISMAY report.
Yeah, I mean, I imagined that this moved into the ISMAY report.
The one-sided, let's look for material that supports the integrity of Horizon.
Yeah, I mean, I hear what you say, and I did...
Well, it was Mr. Ismay saying it.
Sorry?
It was Mr. Ismay who actually said it.
No, I hear what you're saying now, but I didn't know that it was... that you would describe it as a one-sided report.
You're not saying overall in this email, if there is a basis to investigate the integrity of Horizon, we should get on and investigate the integrity of Horizon. This is really important, are you?
Not in so many words, no.
What you were saying by this email is the Post Office will be in serious trouble if we get on with an independent investigation into the integrity of Horizon.
Well, not necessarily. It depends what the independent report was going to say.
No, you say that there were a whole bunch of reasons not even to look, don't you? You come up with a list of reasons. We're going to go through each of them, not even to start an investigation.
Yeah, yes, okay, I accept that, but that wasn't my intention. I think that I overreacted to being excluded from what I saw as being critical to me as the head of the criminal law team.
Did you speak to anyone directly before writing this email or afterwards?
I don't think so, no.
Did you speak with John Scott or Andrew Hayward about it?
I don't think so. I didn't have a great deal of dealings with John Scott, and I'm not sure I knew who Andy Hayward was.
If there was a sufficient level of concern amongst senior members of the Post Office staff about the integrity of Horizon, wasn't the right thing to do to conduct a full inquiry as an imperative, full stop?
Yes.
And doesn't it appear that that had been the plan of senior members of the Post Office right up until your input?
I'm sure my input didn't dissuade them one way or another.
Let's look at the reasons that you give. Second line, you say the consequence will be that to commence or continue to proceed with any criminal proceedings will be inappropriate. That's reason one. Yes.
Yeah.
So if we start an investigation looking at the integrity of the data we rely on, we cannot continue with any criminal proceedings.
Yeah.
Was that an overstatement?
Yeah. Probably.
Why did you make an overstatement?
I think I just wanted to impress on these people that if there was issues going on, I needed to know what they were.
You say, my understanding is that the integrity of Horizon data is sound, and it is as a result of that it is as a result of this that persistent challenges that have been made in court have always failed. Now, at this time, you obviously don't benefit from the wisdom of Mr. Ismay's report. What were you referring to there, that your understanding is that the integrity of Horizon data is sound?
Based on the prosecutions that had been successful.
In how many of those had a question been raised as to the integrity of Horizon data?
I can't remember, but that, I guess a number.
Were the vast majority of them guilty pleas?
I think they ended up as guilty pleas, yes.
And what do you mean by that?
Well, I think we had a number of cases where we were facing trial and the defence decided to plead guilty at the last moment.
Often to false accounting
Yes.
on the dropping of the theft charge?
No. Well, there are, in the papers, there are, I think, 7 references to my charging of offences. 3 were for theft on their own, 3 were for fraud on their own, and 1 was from, in relation to a theft and a fraud, albeit in the advice letter I say that the theft and the fraud are not alternatives. So I was not charging false accounting and a theft or a fraud act offence as alternatives. I tried to avoid doing that at every opportunity.
You continue, these challenges are not new. They've been with us since the inception of Horizon, as it's been the only way that defendants are left to challenge our evidence when they've stolen money or where they need to show that our figures are not correct. What you're saying by that is, what's new here? They're all guilty of theft. They're just coming up with this as an excuse blaming Horizon, aren't you?
No, I wouldn't interpret it in that way. I'm saying.
What are you saying by the only way that defendants are left to challenge our evidence when they've stolen money?
Well, that's if they're a thief.
You're not saying that at all, are you? You're saying that the challenges made to Horizon are a figment of guilty thieves' imagination, and it's the only thing they can come up with when they know they're guilty and they've stolen the money. That's what you're saying by that sentence, isn't it?
Well, I don't view it in that way, but I can see why you do, yes.
Can you explain to us what it does mean then?
Well, we had, right from the inception of Horizon, experienced defendants saying, it wasn't me, it was the system, yet they plead guilty. And that's part of something that I couldn't understand, why somebody who was saying, I'm effectively innocent, would ever plead guilty.
You think you ever thought of the possibility that people did so in order to get a shorter term of imprisonment or a suspended sentence?
Well,
Being of good character, quite often, being trusted post office employees?
I have to say my mentality would be that if I was prosecuted for theft and I was not dishonest, I would not admit it.
So again, this doesn't mean the sentence, the only way they're left to challenge our evidence when they've stolen the money is to blame Horizon.
Well, like I say, I hear what you say.
Well, what do you mean by you hear what I say?
Well,
I'm reading out some words in black and white to you.
yeah,
And
I
you're,
know.
you're
but-
saying that they don't mean what I'm suggesting. Please
Well-
tell us what they do mean.
Well, when I wrote that email, I was annoyed. And I think that's what I've put in there went over the top. And had I been in the meeting on the day, I hope that I would have been a lot more constructive in terms of what I contributed towards the meeting.
Okay, so that's the second reason. First reason is we'll have to stop all criminal proceedings. The second reason is, but these challenges have been around since time immemorial. Can we turn, please, to the next paragraph? What's being suggested is that an internal investigation is conducted. Such an investigation will be disclosable as undermining evidence on the defence in the cases proceeding through the criminal courts. Why would it be undermining?
Well, it would be undermining on the basis that if it revealed that there was anything wrong with the system.
Well, it doesn't say that, does it? You had, your understanding was that Horizon data was sound and that all past challenges had failed. What you're saying here is that the fact of an investigation will be disclosable as undermining the defence.
Yeah.
Why would the fact of an investigation be disclosable
Well,
as
it would-
undermining evidence?
Well, it wouldn't be. You know, it's something that I put in that's erroneous.
So that's the third reason. If we continue, inevitably the defence will argue that if we're carrying out an investigation, we clearly do not have confidence in Horizon, and therefore to continue the prosecution will be an abuse of the criminal process. That's the fourth reason.
Yeah.
Does that involve a very significant overstatement too?
Well, I mean, yes, probably, yes.
Alternatively, we could be asked to stay the proceedings pending the outcome of the investigation. If this were to be adopted, the resultant adverse publicity could lead to massive difficulties for the Post Office, as it would be seen by the press and media to vindicate the current challenges. That seems like a more moderate possibility, doesn't it? If you're conducting an investigation into the integrity of your data, a defendant who is affected by that data may say, stop the prosecution for the moment, adjourn the proceedings.
Yes,
Yes?
yes.
But you give it as a fourth or a fifth reason here. It will adversely affect the Post Office in the media.
Yes.
When you're weighing up, on the one hand, whether to conduct an investigation into concerns about the integrity of data that's used to prosecute people in the criminal courts and potentially send them to prison, and on the other hand, some negative press, which wins the day?
The first.
You continue. The potential impact, however, is much wider for the Post Office in that every office in the country will be seen to be operating a combined system with untold damage to the business. Doesn't that, and the sentence right at the beginning of this paragraph, such an investigation will be disclosable as undermining evidence, suggest that you thought as well, hold on, there might be some system integrity problems here?
I never thought that, no.
Why would an investigation, or an investigation which resulted in a conclusion that the Horizon system enjoyed complete integrity, be seen as the Post Office operating a compromised system in every office in the country?
Well, it wouldn't.
Would only a report that said, no, there are data integrity problems, lead to that kind of untold damage?
Yes.
And so why have you written this in this way? If you didn't think there was anything at all wrong with Horizon, why would untold damage be caused?
I really go back to what I was saying to explain everything apart from the first sentence, in that I hadn't been included in the meeting. I was annoyed and I reacted to that, and I just wanted to put everything on paper which may or may not have been discussed in the meeting. I didn't know. And yes, it was an overreaction. I accept that.
You continue, our only real alternative to avoid the adverse publicity will be to offer no evidence on each of our criminal cases. This should mitigate some adverse publicity, but it's not a total guarantee. That's essentially a repetition of a point earlier.
Yes.
To continue prosecuting alleged offenders, knowing there is an ongoing investigation to determine the veracity of Horizon, could be detrimental to the reputation of my team. This is, I think, the sixth reason you give for not doing it. If we were to secure convictions in the knowledge that there was an investigation where the investigation established a difficulty with the system, we'd be open to criticism and appeal to the Court of Appeal. The Court of Appeal would inevitably be highly critical of any prosecutor's decision to proceed against defendants in the knowledge that there could be an issue with the evidence. Isn't the problem with that you knew from the exchange that it was proposed to be an investigation which is to establish whether or not there was a difficulty with the system, and you were nonetheless proposing to proceed with prosecutions?
Yes.
You say what we really need to do is impress on Fujitsu the importance of fully cooperating in the provision of technical expertise and witness statements to support the criminal and civil litigation now and in the future. So were you saying here, all we need to do is for Fujitsu to stand up and continue to back their system by providing us with their evidence in court, that the evidence is sound?
No, I wasn't suggesting that if it wasn't sound that they should lie. What I was suggesting was that, as a matter of course, we should be getting the full cooperation of Fujitsu on each and every prosecution and civil case.
Were they not fully cooperating?
Well, I think there were tensions between Fujitsu and Pol, which certainly came out in the Misra case, in terms of apparently not wanting experts to talk to other experts.
That hadn't happened yet.
No, but I mean, I think...
That was later in the year.
Was it? Okay.
Yeah, we're March, I think. Yeah.
Well, I just have an impression that there were tensions between Fujitsu and then the dealing with Pol or the investigators or wherever it was.
Isn't this you really proposing an alternative to an independent investigation that actually looks objectively whether there was anything to the challenges or nothing to the challenges. Let's shut this down by getting Fujitsu to back their system.
I never believed that I was senior enough to be able to do anything like that in any event. I mean, I thought that there was no problem in relation to the Fujitsu evidence or Horizon. And as I keep saying, that I think this was me going over the top because I was annoyed that I had not been included in the initial meeting.
I take it you regret deeply sending this email now?
Obviously.
Because on its face it reads like an attempt to shut down the commencement of an independent investigation into the integrity of Horizon, doesn't it?
All I can say is the first sentence. If it is thought that there is a difficulty with Horizon, then clearly the action set out in your memo is not only needed, but is imperative. That, for me, is the crucial bit.
Well, that's where the email should have ended, shouldn't it?
Absolutely, yeah.
Would you really say all of these things with these overstatements and gross overstatements as we've agreed them to be because you were fed up that you hadn't been invited to a meeting?
No, I think wasn't that I was fed up that I hadn't been invited to a meeting. What the problem was if they're not hiding this, but if they're not including me in something like this, then that's pretty crucial to me and my team. Me particularly, running the criminal prosecutions. I need to know if there's a problem. I need to know immediately if there's a problem. And clearly, whatever had generated the meeting must have generated it some time before. And so I'm being kept in the dark. And that's what was rankling me in relation to this.
Did you take it up beyond the sending of this email?
Well, as I said earlier, 5 days later, Dave King emails me saying we're going to do this. We're going to have an internal inquiry, and I think I asked him a question about I think there was mentioned information security or something on that line. I asked what did that mean, and I didn't sort of say don't do it. I've already advised don't do it. I just said thank you very much.
What happened to that internal inquiry?
Well, I believe that was the Rod Ismay inquiry.
Can we turn, please, to poll 0012 0479? And just look at the top of the page, please. We're just before the final Ismay report comes out on the 2nd of August, and he's circulating a draft report, including to you. Can you see that?
Yes.
Why were you being included as somebody who could give comments on the draft report?
I don't know, presumably because I'd kicked up a fuss. They were keeping me in the loop.
And so the proposal that had been initially for an independent investigation had morphed into what became the Ismay report.
It looks like it, yes.
And when did you first know that the Ismay report was being undertaken, investigating the integrity of Horizon?
I don't know.
Well, when you did find out, did you say, hold on, we're investigating the integrity of Horizon? The consequence of that will be we must stop prosecuting every case.
No.
Did you say defendants will argue that the proceedings against them are an abuse of the process?
No.
Did you say the consequence of us investigating the integrity of Horizon will be that they will ask to stay the proceedings pending the outcome of the investigation?
No.
Did you say that the Court of Appeal may be critical and it will be detrimental to the reputation of my team if we continue to prosecute cases whilst there is an investigation into the integrity of Horizon?
No.
All of the reasons that you gave in your 3rd of March document applied equally to a different species of investigation into the integrity of Horizon, didn't they?
Yes.
And the ISMAY report would fall to be disclosed in future criminal proceedings.
Yes, only it's, in my eyes, vindicated the Horizon system.
Let's look at what Mr. Ismay is telling this audience Post Office's priorities are. First paragraph, here's the latest version. It's a complex area. I'd value further comments. And then he gives some timing. Paragraph 3, regardless of how the document is finalised, there are some improvement points that we'll need to work on together. And then there's the priority. The priority should probably be to provide any input considered appropriate for closing down the issues that caused Channel 4 to consider this a news item. Also to ensure we're prepared for the next court cases. Was that the prevailing ethic amongst the senior leadership of the Post Office at this time? The priority was to close down issues that were newsworthy.
Well, if you're telling me that Rod Ismay was told not to report on anything that was detrimental, then it probably was.
Did you provide any additional input with the aim of closing down issues that caused the media to consider this to be newsworthy?
I don't recall giving any input to his report. It may have been that I supplied some statistics in terms of numbers, but I recollect, my recollection is that I received the report and that was it. I didn't contribute to it in any way. Now, I don't know what Rod Ismay would say my contribution was, but I can't recall one.
Well, he said that the list of people to whom it was distributed, he couldn't explain why, in relation to a lot of them, it was distributed to them.
Yeah.
Can we turn then to the report itself, poll 002 6572. We can see it's dated the 2nd of August, and you're one of the addressees.
Yes.
And if we scroll down on the first page, please. On the first paragraph of, the paragraph above executive summary. This paper has been compiled as an objective internal review of Pol's processes and controls around branch accounting. Mr. Ismay told us that that sentence was incorrect. It wasn't objective at all. It was a one-sided picture which didn't look at any evidence that there may be problems with Horizon. It only collected together existing accounts of how reliable Horizon was. He continues under his executive summary, the allegations to which we're responding follow on from cases where thousands of pounds were missing at audit. We remain satisfied that this money was missing due to theft in the branch. We do not believe that the account balances against which the audits were conducted were corrupt. And is that the headline that you took from this?
Yes, I think, yeah, one of the headlines, yes.
Can we go forward to page 19, please? And scroll down, please. Here he addresses the possibility of independent review or independent audit. And he says the Post Office has actively considered the merits of an independent review. This has been purely from the perspective that we believe in Horizon, but that a review could help give others the same confidence we have. Our decision between IT, legal, product and branch accounting, security and press office has continued to be that no matter what opinions we obtain, people will still ask what if, and the defence will always ask questions that require answers beyond the report. Just stopping there, were you party to a decision as a representative of legal that included that amongst its reasoning?
I don't think so. As I said before, I can't recall having any input to this document. A lot of the information in it I wouldn't have been privy to, with the exception of possibly the case numbers.
But this isn't about a conclusion that's reached. This is explaining why we haven't gone to an independent reviewer or auditor. And it's suggesting that amongst those that were party to a decision not to do so was legal. Was that you?
I don't recall ever having had dealings with Rod Ismay on the phone or in meetings. I don't think I ever met him. And I didn't recognise the name when it first came up. I don't think it was me, no.
We'll skip over the next couple of paragraphs, please, and go to the next page. He then says it's also important to be crystal clear about any review if one were commissioned. Any investigation would need to be disclosed in court. Although we would be doing the review to comfort others, any perception that the Post Office doubts its own systems would mean all criminal prosecutions would have to be stayed. It would also beg a question for the Court of Appeal over past prosecutions and imprisonment. The first two sentences of that paragraph are essentially what you were saying in your March email, aren't they?
Yes.
The last sentence, it would also beg a question for the Court of Appeal over past prosecutions and imprisonments. That's not something that you raised in your email, was it?
I don't recollect raising it, no.
Do you know where that came from? Which sounds like something that a lawyer might advise. If we get an independent review, you should be aware that it might call into a question all of the convictions of the sub-postmasters that we've obtained over the years.
Yeah, I think that I remember speaking to Dave King, who I think was part of the group that involved this report. So it may have come from me to Dave King, but I don't ever recall speaking directly to Rod Ismay.
Can we, shortly before we break for the day, turn lastly to poll 00105593. This is a new document that we haven't looked at before, I think. It's dated the 28th of March 2012, so we're a year and a half on. And it's an email exchange between Chris Darvill and Susan Crichton. And if we scroll down to the foot of the page, please, we can see who Chris Darvill was. Is that a name that's familiar to you?
No.
Looking at his designation and the address given, and bearing in mind this is March 2012, where do you think Mr. Darvill sat within the legal services offering of the post office?
I think he was in the Post Office Limited team, solicitors team.
And so that's what neither the criminal law team nor the civil law team,
Yeah,
but
that's
something else.
something else, yes.
If we go up, please. He says, under the heading Comments from Rob Wilson, Susan, the earliest Rob can speak to me is 3 p.m. I've told him that you are meeting with Alice, I think it's probably Alice Parsons, at 3:30 p.m. He has, however, sent over a few initial comments. Sorry, just scroll up. We'll see when we look at the whole context here that this appears to be another exchange about commissioning an independent audit in 2012. And Mr. Darvill says that you, quote one, have concerns regarding the public relations implications over an audit being conducted. I guess the point here is carrying out an audit in response to the noise surrounding the integrity of the Horizon system potentially looks reactive and will be seen as the post office having lost confidence in the system. 2, Rob also has concerns regarding the costs that would be incurred in carrying out an audit. Depending on the scope of that audit, the cost could potentially be significant. 3, an audit commissioned by the Post Office may not have the desired effect of curbing these challenges in any event. It will always be said that the audit was not independent. Ultimately, the only way to avoid criticism would be to appoint a joint expert. 4, Rob does not believe an audit would have a great impact on current prosecutions in the sense of finding a, quote, smoking gun, which explains that the losses were due to computer error. But if the Post Office is required to disclose that an expert has been appointed to conduct a review, there'd be a strong argument that the cases should be adjourned pending the outcome of the review. I will need to test with Rob the extent to which this would need to be disclosed. 5, Rob remains firmly of the view that an audit should not be carried out. In his words, quote, Pole has to grit its teeth and get on with prosecuting and defending civil actions. Was it your view that Pole should just grit its teeth and get on with prosecuting people?
I think so, yes.
Just carry on regardless.
Well,
More important than whether or not there was a problem with the system was public relations and cost.
Well, I didn't believe that we had a problem with the system because of the Rod Ismay report. And by this time, we'd had the Seema Misra case, which had been fully challenged. And,
Did you regard that as a resounding success?
well, I didn't regard it in the same way as Mr. Singh. No, I didn't think it was going to deflect the defence from continuing to say that they had problems with Horizon. I imagined that there would still be challenges in relation to the Horizon system.
The views that you're recorded as giving here, do you doubt that you gave them in any way? We haven't tracked down a communication from you to Mr. Darville.
No, I've no reason to suspect that he's got it wrong. I mean, he may have emphasised it. I may have emphasised it in a slightly different way, but I think essentially I was saying that, look, from my perspective, the system has been vindicated by a report. If you want to do another report that's internal, that you're wasting your time, basically. If you want to do an external report, well, that may be a different matter. But
This was about an external audit.
yeah, right, okay.
Because I think it talks about the costs.
Yeah, so, you know, in the end of the day, it's going to be your decision. I'm staying in Royal Mail, you're in Poll. You know, you're going to have to decide. But as far as my view is concerned at the current time, is that we've already had a report and it's vindicated us.
The ISME report, so it all stacks. All of this hinged on ISME, did it?
Well, yes, but I didn't know that what you've told me this afternoon. I never understood that that was the position. If I'd realised that that was the position, then it would be completely different.
Thank you very much. They're the only questions I ask you presently until December. I understand that none of the call participants are going to ask. Oh, in fact, my apologies, Ms. Jacobs is going to ask some questions. My mistake.
Sir, just a quick question from me. I want to ask you about paragraph 18 of your statement. I represent 157 sub-postmasters and I'm instructed by Howe & Co. So if we go to page 10 of 36, and that's WITN 0421 0100, page 10. What you say there is, in the event that the defendant was acquitted following trial, I would contact prosecuting counsel and ask for a full report with a view to understanding the reason for the acquittal. And one of our clients is Suzanne Palmer. She was acquitted by a jury after a 3-day trial in relation to 3 counts of false accounting. That was in January 2007. The jury accepted that she had not acted dishonestly, and they accepted what she said about the problems in the system. And what I want to ask you is what it was that you were trying to understand after an acquittal. Did acquittals, such as this one and others, cause you to think that maybe there was something in what the sub-postmasters were saying about the Horizon system, and that at least there should be an investigation?
Yes, if counsel had said to me, yes, I do have concerns over the Horizon system, then yes. Sorry, but apologies, but I can't recall the case, and I can't recall what counsel said in relation to the acquittal. But yeah, I mean, I think had counsel said to me, look, Rob, we have a serious problem here, then yes, I would have done something about it.
But if the fact that a jury had rejected what the Post Office was saying about the honesty and integrity of a person who is appointed because they're a person of good standing in their community, if a jury had rejected that there could possibly be an integrity issue with the Horizon system, surely that ought to have caused you to have paused, and it should have been an alarm bell, regardless of what counsel said.
Well, I don't know why the jury acquitted your client.
Right. Now, it seems to our clients, particularly in light of the passage that Mr. Beer took you to when you say these challenges are not new, they've been with us since the inception of Horizon, it's always been the only way the defendants are left to challenge our evidence when they've stolen money or when they need to show that our figures are not correct. It seems that your view and the view of Post Office were entrenched. And when you say in your statement that you tried to understand the reasons for an acquittal, what you were really doing was looking to see what you could do in future to make sure that didn't happen again and secure more convictions to get it right next time.
No.
That's right, isn't it?
No, it wasn't. No, it was a genuine request for information to understand what had gone on, not to strengthen our case in the future, no.
So finally, you didn't think then, did you, that an acquittal is a significant event that ought to have at least caused some sort of internal inquiry or investigation?
Well, no. Well, it did, in the sense of requesting a report from counsel, and had counsel expressed any reservations, I would have obtained a transcript of the trial, and that would have been examined. I do recall during the course of my period as the team leader requesting transcripts, not very often, but I do recall doing that because I wanted to find out whatever it was that I needed to find out.
Well, thank you. I haven't any further questions.
Thank you.
Mr. Beer, Mr. Wilson is returning in December with other witnesses who have had such a long delay between their tranches of evidence. I have released them from the prohibition on them talking about the evidence generally, as far as I recall, i.e. I haven't said anything along the lines of you mustn't discuss the evidence which you have already given or anything like that. In this case, I don't see any reason to depart from that general practice, but I'd be grateful if you or anybody else has any observations about that.
Thank you, sir. No, there's no reason to depart from what you've just said, and every reason to do it, in particular because Mr. Wilson has got to write his second witness statement and may require the assistance of his lawyers to do that.
Yeah. And nobody else is shaking their head vigorously saying we've got it wrong, are they?
No, they're not, sir.
Right. Well, Mr. Wilson, thank you for giving evidence during the course of today. And you are now able to speak about your evidence with your lawyers, or for that matter, anyone else. But you appreciate that you will be required to return on a date in December to give further evidence.
Yes, I do, sir. There's nobody else that I could really speak to.
Fine. Well, you don't have to offer an explanation, but thank you anyway.
Right, thank you, sir.
So we return tomorrow at, I think, 10 a.m. for Paul Inwood and Thomas Pegler.
Yeah. Thank you very much, Mr. Beer. I'll see everyone in the morning.
Thank you very much, sir.